Right, it is March 27th, and we are taking up H44 and Senate Judiciary. We have Ben Dobrowski, election counsel with us to go along.
Morning, good evening. So as Mr. Chair said, Ben Dobrowski from the Office of Legislative Counsel. For the committee is H44, an act relating to miscellaneous amendments to the laws governing impaired driving. And it is a 23-page bill. However, the changes aren't as substantive or as lengthy as it may appear. A lot of the bill contents are included really for context, because there's a lot of, as you'll see, sort of cross references to other sections. And so it just helps with the understanding of the bill as a whole, if you're so inclined to read it one by line. But really what this bill does is it makes several changes to the impaired driving laws, a lot of technical corrections, gender neutral pronouns updates, some closing loopholes to ensure that the Department of Motor Vehicles is notified of license suspensions related to impaired driving offenses. And then really in my view, the most substantive change is basically creating a process for someone to refuse compliance with a warrant for blood draw without essentially creating a disproportionate penalty, to keep it within the umbrella of impaired driving offenses rather than converting it to a more serious crime because of that refusal. And I'll get into the context of that as we get there. But that's really sort of the main thrust of the bill. So I'll start with section 1, which really is involves those technical changes, if you will. You'll see on line 12 of page 1, just a reference to 33 VSA chapter 52A. That's the youthful offender chapter. You're going to see here that juvenile is struck because it's not the precise term. We have children, we have youthful offenders, we have delinquents. We don't have juveniles anymore. So this is really just a cleanup within those particular sections. You'll see later on a reference to Superior Court on line 20, striking misdemeanor because family court can hear felony offenses as well. Striking pending on July 1st, 2016, just because it's not really relevant at this point anymore to have a time limitation there. And then you'll see on the beginning of page 2 on line 1, a reference to 5281 of Title 33. That's the motion in the family division to convert a case to a youthful offender status. So again, these are sort of just technical cross references to ensure that if these cases are heard in family court, the correct laws are being cross referenced in that context. You'll see on line 2 a reference of conviction or adjudication, because in family court we don't have convictions, we have adjudications. You'll see on lines 4 and 5 that there's now conviction has been added to have the same meaning as the 23 VSA 460, which in that case, what that is it's an unvacated final adjudication of guilt, final determination that a person has violated, basically any sense of what could provide a final order in a court case. And so just ensuring, since it's family division, all forms of that is considered, because again, we don't have traditional convictions in that context. Any questions before we move on to section 1200 of Title 43? Okay, we'll see here that this is the definition section. So on line 11, the definition of serious bodily injury has been added because previously in the statutes there were individual cross references throughout. So we're striking those and then just adding it to the definition. So anytime it's mentioned, you don't sort of have that superfluous cross reference language. So again, technical. You'll see here in section 1201, this, for context, is the drunk driving statute in our state. You'll see that there are various bases for impaired driving violations in 1A, B, C, and C rather. Excuse me. But you'll see as we go through, some technical changes on line 17 of page 3, just updating gender control pronouns.
Can I just interrupt for a moment?
Yes, of course.
Bottom of page 2, existing statute. I never knew you could operate a school bus with some concentration of alcohol in your blood. Is that, what would be the rationale for? Because I'm thinking in Sweden,
Mhm.
the statute is zero for everybody operating everything. But especially a school bus, like, why would we be making sort of?
That's a good question. I don't
Point
have.
oh two is the equivalent of one drink. So if you have one drink, you're at the 0.02.
Yeah, but my question is, do you want a bus driver having one drink?
Well, if you have one drink, you're probably gonna be at a 0.02.
But that's,
So I guess if you have half a drink.
it's
then
like,
you're fine. I don't know.
it seems like in the law, we're saying, well, you can have a little bit if you're a bus driver. I mean, I don't know, it seems sketchy to me.
Maybe it's still the street defense. I don't.
Yeah, it's probably been that way for forever, but.
Right. Well, and you'll see as we go through this too, there are some updates kind of in that same vein. But yeah, what's interesting is, you know, in our impaired driving statute, there's the 0.08, which is sort of everyone thinks of, that's the violation.
Yeah.
But then, you'll also see in subdivision 2 on page 3, when a person is under the influence of alcohol. So you can technically be charged with an impaired driving offense if you're below that. Because what subdivision 2 is a vestige from is from like the 1930s, before we had chemical tests. This was the standard. So there is some wiggle room where maybe you don't meet the technical 0.08 violation, but you can still be impaired. So there is a basis to charge you for that impairment if you show the signs.
Oh, and then 3 is what allows for drug recognition experts,
Correct.
because they don't have to determine on the quantity, they just say.
Based on your signs. Yeah, exactly.
And where's the, and I'm just remembering now, there's also the language of, you know, impaired to the slightest degree.
So that's coming out of subdivision 2 there.
Yeah.
And that's that, there's a 1930s case that talks about that. And again, it comes from that time before chemical testing was done. So interesting nuances to this law.
What was that?
Never knew that.
Yeah.
I know.
So you'll see on page 4 that there's an addition in subsection F, which is on lines 16 through 17. The addition of A or J. So what this says is that a person may not be convicted of more than one violation of subsection A, which is what we were just reviewing. So you can't be charged with both a 0.08 violation and a violation under that subdivision 2 of impaired driving. The prosecutor or the police officer will have to pick. And then J is added to that picking, if you will, because what J is being added and what that says, and this was talking about that substantive change I referenced before, that a person suspected of violating this section shall not refuse to submit to the collection of an evidentiary blood sample when a warrant for that person's blood is issued pursuant to subdivision 1202 F1 of this title. What that subdivision is the warrant requirement for instance, let's say a drug recognition expert that sees signs of impairment, but you're not impaired through alcohol. And so the police officer would request a warrant to do a blood draw. Because, and the reason why there's a warrant requirement for blood draws as opposed to say PBT roadside testing is because it's more invasive.
Yeah.
And so what this is doing, and we'll see this as we go through it, is creating a procedure so that someone you'll see is that they can't, if they refuse this blood draw, which Walla says you can't do it. There is a process to in this, because previously, if someone didn't comply with a warrant for blood draw, there was really no recourse for the police officer other than filing a charge for, say, hindering arrest or obstruction of justice, and those are felony penalties. And everything in the DUI context, unless you are a repeat offender or you've caused serious bodily injury are misdemeanors, and the rehabilitative consequences inherent to these penalties, which if you get charged for obstruction of justice, you're now sort of outside of that DUI law umbrella where you have those rehabilitative crash course, all these things about impaired driving to learn whether or not you have this problem. So it kind of takes it out. So this is trying to keep it within that realm. And you'll see again in lines 15 through 17 that this doesn't impair the person's right to challenge the validity of the warrant. So if the underlying facts of the warrant are questionable, they still have the ability to challenge that. However, this is again creating that procedure to comply with that warrant requirement.
Is criminal refusal a crime now?
Yes.
So,
And this creates a criminal refusal for a refusal of a war-based blood drug. No, it wasn't that. So that was sort of this gap in the law, if you will, that elevated or escalated rather the facts in this case something more serious when maybe it wasn't appropriate.
so they get charged with criminal refusal and it can be introduced against them in court.
And that's based off of the current law in other contexts when it comes to, let's say, the evidentiary test back in the station where you would blow. If you refuse to do that, that's a criminal refusal that can be offered in court. So this puts it on the same level as that.
Yeah, which makes sense.
And that's a misdemeanor? That criminal
Refusal, yes, for the first time you refuse it, it is. So we're going to go into section 1202. And this gets into sort of that consent and implied consent that we started touching upon here. So you'll see in A1, this kind of sets the stage that the implied consent concept in our state is sort of this bargain for exchange, if you will, between the state and motor vehicle licensees, where, okay, we're going to say you have the privilege to use the roads and drive and get around, but in exchange for doing that, you have implied consent to submit to these evidentiary tests that we may need to take to ensure the safety of you engaging in driving. So we have blood tests, we have saliva tests, and then also the evidentiary tests under A1 that I mentioned about going back to the station. So that's the bargain for exchange, if you will. Now, this bill doesn't change any of those per se. However, you'll see later on, and again, there's a technical change on line 12, page 7. But you'll see later on that in subdivision 6, this is sort of what creates the criminal refusal. So if a person refuses to take the evidentiary test, it may be offered into evidence against the person, whether a search warrant is sought or not. And they may be charged with a crime of criminal refusal if they've previously been convicted of impaired driving, if they've been involved in a crash or collision resulting in serious bodily injury or death, or now subdivision C, where the person refuses the collection of an evidentiary blood sample when a warrant for that person's arrest is issued pursuant to subdivision F1 of this section. So it creates that process to keep it within that impaired driving umbrella without escalating it. Any questions on sort of the process that's being outlined in the bill? Okay.
Yeah.
And then you'll see in subsection E, again, a gender neutral update. And then in F1, this is the blood test. If you're so inclined to get into the details of it, but essentially, if a law enforcement officer thinks that you're impaired and a blood test is sought, they have the ability to obtain a warrant to get it. Where'd you go? I'm on page 10. So we're scrolling through because there's a lot of, like I was saying, a lot of this is included for context, but there are a whole lot of changes. Yeah. Now we're getting into Title 23, Section 1205. This is the civil suspension of a license. So in a DUI context, you'll have the criminal charge, but you also have a parallel civil process to suspend your license as well. They're parallel processes, but there is an unintentional gap in the law. So if you see right on line 17 of page 10, the addition of at or above the legal limits. So there was a gap where under 1201, it was at or above 0.08. But in 1205, the language had read above 0.08. So there was a 0.01 gap between the two statutes, and this closes the gap. So,
Well, yes, there's a gap, but why the decision to close it one way and not the other?
my understanding is that 0.08 was the intended threshold.
I see.
And so this brings it in line with that. And so you'll see throughout section 1205, this update, page 11, line 3, at or above, a limit specified. And then that's throughout, in addition to some gender neutral updates. We'll see here again. Line 17 on page 12. And then you'll see here, and this is kind of the start of some other updates too, to notify the Commissioner of Motor Vehicles of these license suspensions. So you'll see on page 13, line 6, that a copy of the officer's affidavit when they pull someone over for impaired driving, right now it was mailed first class, or given to the defendant. It's also going to be sent to the Commissioner of Motor Vehicles so that they are aware of the facts underlying the potential suspension. And then you're going to see that later on. Again, we'll see on line 15, providing the criminal division and the state's attorney with a copy of the notice of intent to suspend. So when you're pulled over, you're given the criminal charge, but there's also on the civil side, notice of intent to suspend your license, where you have to then, if you want to refute that, mail in your refutation within, I think it's 7 days. If you don't, the suspension goes into effect the 11th day after the incident. So this just, again, make sure that the court, in addition to the prosecutor, has all the information necessary to make these decisions. You'll see later on, again, another at or above reference on page 14, line 7 of line 14 of page 14. And then no other changes really, except for, again, another at or above change on page 16, line 1. And then again on line 13. And so that kind of finishes up the 1205 loophole closing, if you will. Any questions on that? So then there's these penalties under 23 VSA 1210. And so what had happened, to set the stage for this, there were DUI penalties where if you cause an accident and either death or serious bodily injury resulted from, let's say, a crash that were impaired driving, the way that the statutes had been outlined is that you had to choose if where, let's say, an incident happened where there was both a serious bodily injury and death. The statutes didn't allow for the prosecution of both of those incidents. You had to choose serious bodily injury or death. What this does is permit the prosecution for such a circumstance. So if both a serious bodily injury and death happened in an impaired driving collision, the penalties now allow for now allow for that prosecution, the penalties that result. So essentially, the statute restricted that the enhancement for those crimes, the enhanced penalty for that, because again, if you had to choose if it was a serious bodily injury or death, this now says both can be the basis of an enhanced penalty, because it really essentially led to an unnecessary restriction in the prosecution's ability to create accountability for that.
So just to clarify, this is for, I'm looking at line 6, this is for more than one person. So if you're DUI, you crash into somebody, you kill one person in the car and seriously injure the other person, then you can be charged with death resulting and causing serious bodily injury, two separate charges.
Mhm. Yeah, and at least that penalty enhancement before you have to kind of choose.
So, but you wouldn't be able to, back if you're drunk and you crash into somebody, you cause serious bodily injury and they die a week later, you wouldn't be able to charge them with serious bodily injury and death resulting.
Well, I think that's a factual question.
Yeah.
You know, if someone died as a result of the crash, you know, maybe weeks later, I think you could make that charge, but it's hard to say right now what the restrictions may.
Senator Mathis, good.
That was my exact question. Yeah.
Yeah, and I think that, you know, what could probably happen is that you could file an amended charge if someone dies later on for that death resulting. And those are felony penalties.
Yeah.
If that occurs. And so you'll see, again, just throughout or serious bodily injury. And then you'll see, this is what I was talking to, where in subsection G on page 18, those serious bodily injury cross references, where we're striking those because now they're defined in the definition section. And serious bodily injury is really like maiming, losing limbs, serious impairment of health, really serious injuries.
What's that first one?
You know, like losing limbs and things like that. Yeah, exactly. And so you'll see these updates kind of throughout this portion of the cross references and then the decedent death resulting that language. So now that ends section 2. We're in section 3, and really what section 3 and 4 of the bill does is that closes those notice loopholes to the Commissioner of Motor Vehicles. So you'll see here on page 20 in subdivision 2 that an order of delinquency and proceedings has been changed to a merits adjudication order issued pursuant to section 52.29. So these are orders that would be sent to the DMV to notify them of these license suspensions. We're changing it from delinquency because these orders don't always result in delinquencies. They're merits adjudications. And then also adding youthful offender because it's not always children that are involved in these family court proceedings. Kind of an anecdotal analogy is back when I used to practice in privately and I was doing some criminal defense work, you know, our clients would ask, well, when's my license going to be suspended? And, you know, we would always advise, oh, well, act as if it's suspended right now. But in the back of our minds, we'd always sort of question whether or not DMV would ever get the notice because of these loopholes that are now being closed on the notice requirements, because the court didn't always send the DMV the suspension notices. And so sometimes our clients' licenses wouldn't always be suspended. That's the situation that this is attempting to remedy. Yeah. And you'll see the addition of subdivision 3 here, that a merits adjudication ordered pursuant to section 5229 shall be reported to the Commissioner of Motor Vehicles in accordance with the notice procedures under Title 23. And then you'll see here that section 4 merits adjudication portion shall send a record of the adjudication to the Commissioner of Motor Vehicles within 10 days of its issuance. So all in line with trying to close that loophole. Any questions on that before we get to section 5?
No.
I saw the wheels going for a second. So section 5 came out of this discussion about the twofold. One, impaired driving stops typically take a long time to do the testing and holding someone there, and also requires a lot of paperwork on the part of the law enforcement officer. Section 5 is aimed to create a task force to reduce the processing times and paperwork attendant to impaired driving offenses. So essentially, what this is going to do is gather a bunch of people together, the chief judge, the defender general, the commissioner of public safety, commissioner of motor vehicles, executive director of the states of DSAS, and the president of the Sheriff's Association and the Police Association to get together to find out ways to reduce the amount of time that someone is held roadside and also reduce the paperwork necessary for a law enforcement officer to file. But it needs to be within certain boundaries. One, ensuring that constitutional and statutory requirements of implied consent are followed, how those requirements related to implied consent affect the duration for which suspected impaired drivers are held. Because right now, in our laws, we have an additional statutory requirement to actually go through the implied consent statute line by line to someone roadside. And there was a lot of testimony in the house how sometimes it's really difficult when you have someone that's impaired because you're going through it, but they may not be able to understand it anyway.
If I can interject, it was a very lengthy process that I used to think was insane. So if you have a car, the DUI car stop, and everything goes smoothly, it's going to take at least 2 hours from start to finish to do everything. There's some DUIs that can take 4 or 5 hours, depending on, injuries, if you're drawing blood, and that sort of thing. But, envision, you arrested somebody for DUI, you're back at the barracks, and they're very drunk. You have to read, I think it's 5 or 6 pages of legalese in 10-point font. You have to read every single word, ask them if they understand after every paragraph or so. And, it's a weird process. I should bring in a copy of what the DUI processing paperwork looks like. So I'm glad there's a task force to figure out how to shorten the amount of paperwork and also shorten the duration in which somebody gets held. The process. It would be great if we could figure out something now, but maybe we can figure that out. Yeah.
I understand what Ben is saying and what you just said, Mr. Chair. I still don't understand the concept of implied consent and how it is central to what we're talking about.
Right. So with implied consent in this context, it's part of those statutory requirements, that lengthy several page document is a recitation of the implied consent law.
So it's just referring to the reading of like Miranda rights are a concept, but they're also like a procedure that you have to follow. So we're targeting here the procedure of reading these things.
Right. And essentially whether or not you can cut down on that procedure, but still adhering to the constitutional principles of implied consent, and everything else that needs to occur to ensure that those people who are pulled over maintain full access to their rights.
Right.
But also helping law enforcement by cutting down on maybe some unnecessary work. And so
What happens like in the situation you were describing when you have to read down through that whole thing? What happens if somebody answers no? I know everything.
And you just have to go back and reread it. And you have to make a reasonable effort to explain it. I mean, you're not acting as their lawyer, but and then it ends up in the hands of the jury to decide, was this person too impaired to understand their rights?
Yep.
Or did they just say no over and over, even though the officer made reasonable attempts to explain what their rights are?
it potentially creates an issue that needs to be resolved in litigation, where you have the statutory requirement that may not be constitutionally required, but the person refused or didn't understand. And now you have to, as the chair said, you have to kind of litigate this issue to determine whether or not the decision.
Would you put them back in the holding facility until they're sober enough to understand?
You can't quite do that because you have to maintain observation of them for a certain period of time. Because for example, if somebody burps, literally, if they just burp in the middle of the process, you have to start from the beginning. So, yeah,
And this can also happen roadside as well, in addition to the station. So it just creates sometimes a tenuous situation.
Can you not do that blood test until after you get through that 5 pages? So to be able to consent.
So the blood test is if you're not able to get an evidentiary breath test. So for example,
Which you don't have to agree to, right?
well, you've technically already agreed to it through implied consent. But the blood test is if the evidentiary test isn't going to work because let's say the DUI driver gets into a crash, they kill somebody, they're on their way to the hospital. You're not going to be able to carry the table with the evidentiary breath test to the hospital. So you'll have to draw blood, or if it's a drug DUI.
Or if they're too impaired, this will take it. But then that creates another weird situation because, okay, so you get the warrant, take them to the hospital. There's a question whether the doctor will actually do it if they're not in a position, if they're not coherent enough to consent to the doctor. So it just creates this whole kind of downstream issues that essentially would have to be resolved in litigation. So this task force has the assistance of the Department of Public Safety and comes back with a report on November 15th this year in the form of proposed legislation to this committee and to the House Committee on Judiciary with any recommendations for legislative action. Meetings start on or before August 1st. They select a chair from among its members. Meetings are capped at not more than 6. Standard quorum requirement, and the task force ceases to exist on February 1st of next year. And then compensation and reimbursement where they're not otherwise compensated and reimbursed for their attendance. They'll be entitled to compensation reimbursement through their BSA.
Seems like everybody would be, but.
Yeah, that's the testimony that's been prepared so far, is that everybody more or less will be covered by this. And then section 6, the act is back on July 1st, 2025, or pass.
Although I guess they could think designees.
And probably because of this will go to operations
And approach.
and purpose.
Did House Judiciary any progress or put out any ideas regarding some of the potential ways to make processing a bit more streamlined, or did they just say it's too complicated, let's make it passable?
It was the latter.
Any questions or comments? Yeah, it's too wise, right?
Yeah.
Yeah, the nuances of the DUI laws are not as well known as probably they should be.
Yeah. That's. Alright. So that. So we've got H118, we've got Julio coming in at 10. Then. I guess we can adjourn at 10 o'clock.
Oh, and I should say too, on H118, Michelle's gonna take that bill over. We're